The Supreme Court is once again at the heart of America's gun debate, standing as the final arbiter in a nation deeply divided over the meaning and limits of the Second Amendment. As the justices prepare to take on new cases, the eyes of the country are fixed on Washington, D.C., waiting to see how the highest court will interpret the Constitution in a rapidly changing society. In the coming months, the court is preparing to hear cases that could fundamentally reshape gun laws for decades to come, setting precedents that will ripple through every state and community. This isn't just a routine review. These cases will test and potentially redefine the very core of the Second Amendment, challenging long-held assumptions about individual rights and public safety. The catalyst for this new era is the 2022 Bruen decision, a landmark ruling that upended how courts judge gun laws and created legal chaos nationwide. Since then, lower courts have struggled to interpret the new standard, leading to a patchwork of conflicting rulings and uncertainty for lawmakers, law enforcement, and citizens alike. Now, the Supreme Court faces the urgent task of clarifying what the Second Amendment really protects, and where the line should be drawn between individual rights and collective security. The cases before the court are not abstract, they are real, immediate, and deeply personal for many Americans. For example, can legal marijuana users own guns, or does federal law still bar them from exercising their rights, even in states where marijuana is permitted? Can states ban firearms on most private property open to the public? Or does that infringe on constitutional freedoms? These questions strike at the heart of how Americans live, work, and interact in their communities. The stakes are enormous, with potential impacts on age restrictions for gun ownership, the legality of semi-automatic rifles, and the power of states to regulate firearms in public spaces. The outcome could reshape the landscape of American gun rights and regulations for generations. The court's decisions will affect millions, from law enforcement officers on the front lines, to families concerned about safety, to everyday citizens exercising their rights. In this video, we'll break down the history, the key cases, and what's truly at stake for you, your family, and your community as the Supreme Court opens a new chapter in America's ongoing debate over guns and the Constitution. To understand how we arrived at today's fierce debates over gun rights, let's take a step back and rewind the story. The path to the current legal landscape is shaped by a series of landmark Supreme Court decisions that have redefined the meaning of the Second Amendment in modern America. In 2008, the Supreme Court decided District of Columbia versus Heller, a case that would become a turning point in American constitutional law. The court ruled that the Second Amendment protects an individual's right to own a firearm, specifically for self-defense within the home. This was the first time the court clearly stated that the right to bear arms was not just about militias, but about personal protection. Just 2 years later, in 2010, the court took up McDonald versus Chicago. This case asked whether the Heller decision applied only to federal laws, or if it also limited state and local governments. The court confirmed that the right to keep and bear arms is fundamental, and that states and cities must also respect this right. This ruling extended the Second Amendment's reach across the entire country. Together, Heller and McDonald set a new constitutional baseline. Americans have a protected right to own guns for self-defense at home, and this right cannot be easily taken away by any level of government. These decisions reshaped the legal landscape and sparked new debates about the limits of gun regulation. But after these landmark rulings, the Supreme Court went silent on gun rights for more than a decade. Lower courts struggled to interpret the new standards, and many questions about the scope of the Second Amendment remained unanswered. That silence ended in 2022 when the court took up New York State Rifle and Pistol Association versus Bruen. This case challenged New York's strict rules for carrying concealed handguns in public, arguing that the state's requirements were too restrictive. In a sweeping decision, the court ruled that the right to bear arms is not limited to the home. Bruen struck down New York's law, declaring that Americans have a constitutional right to carry firearms in public for self-defense. This ruling dramatically expanded the reach of the Second Amendment, but perhaps even more importantly, Bruen changed the way courts must evaluate gun laws. The court replaced the old balancing test with a new historical standard. From now on, any gun regulation must be consistent with the nation's historical tradition of firearm regulation. Judges must look to history, not just modern policy arguments, to decide if a law is constitutional. This new, stricter standard has opened the floodgates for legal challenges. Across the country, gun laws that were once considered settled are now being questioned, as courts and lawmakers scramble to interpret what counts as historical tradition. The Supreme Court is once again at the center of the national conversation, facing pressure to clarify the rules it set in motion. With new cases on the docket, the justices are being asked to define the boundaries of the Second Amendment all over again. The aftershocks of Bruen are still rippling through courtrooms nationwide, shaping the future of gun rights and gun laws in America. The story is far from over. Bruen's new history and tradition test means gun laws must have roots in the 18th or 19th centuries. Courts now scramble to find historical analogs for modern regulations, often with conflicting results. Laws on domestic violence, felons, age limits, and assault weapons are all in legal limbo. This patchwork of rulings is why the Supreme Court must step in again. The upcoming cases will test how strictly the court wants to apply its own standard. The answers will determine whether Bruen sparks a revolution in gun law, or just a narrow shift. One of the most closely watched cases this Supreme Court term is United States v. Heightened. At its core, the case challenges the federal law that bans gun ownership for anyone who uses illegal drugs, regardless of whether they have a history of violence or not. This law has been on the books for decades, but recent changes in both gun rights and drug policy have brought it under new scrutiny. The case began when a Texas man was found in possession of both marijuana and a pistol. Under the Supreme Court's Bruen test, which requires gun restrictions to be consistent with the nation's historical traditions, his charges were dismissed by a lower court. This decision has sparked a national debate about the intersection of drug use and Second Amendment rights. With over 50 million Americans using marijuana each year, many in states where it's now legal under state law, a Supreme Court ruling could dramatically reshape federal gun policy. The outcome could affect millions of people who use marijuana recreationally or medicinally, as well as those who use other controlled substances. The government argues that the ban is rooted in a long-standing tradition of disarming people considered untrustworthy, such as habitual drunkards or those deemed dangerous to public safety. They claim that drug users fall into this same category and that the law is necessary to prevent potential harm. Opponents, however, argue that there's no clear founding-era precedent for disarming people simply because they use a substance. They point out that the founders did not enact blanket bans on gun ownership for people who drank alcohol or used other substances, and that today's law is overly broad and unfair. Lower courts across the country are divided. Some judges have ruled that the law sweeps too broadly and infringes on constitutional rights, while others believe it is justified by concerns about public safety and historical practice. This split has made the issue ripe for Supreme Court review. The Supreme Court's decision in Heightened will clarify what kind of historical evidence is required to justify disarming an entire group of people. It will also set a precedent for how courts interpret the Second Amendment in the context of modern social issues. Ultimately, the ruling will help define whether the Second Amendment protects only those deemed virtuous by society, or if its protections extend even to those whose choices are controversial or disapproved of by the majority. The outcome could have far-reaching consequences for both gun rights and drug policy in America. Another key case is Woolford v. Lopez, challenging Hawaii's law banning guns on most private property open to the public unless the owner gives explicit permission. Challengers argue this flips the default. Instead of guns allowed unless posted, it's guns banned unless allowed. They say this makes it nearly impossible to exercise the right to carry in daily life. Hawaii and the Ninth Circuit argue the law respects private property rights. Owners should decide what's allowed. The Supreme Court must balance the right to bear arms with the right to control private property. If the law is struck down, states may lose the power to create broad gun-free zones. If upheld, it could become a model for other states to restrict public carry. This case will define where the right to carry truly applies. The court is also considering whether to hear cases on age limits, felon bans, and assault weapons. Some states bar 18 to 20-year-olds from buying guns. Courts disagree if this is constitutional. There's also debate over lifetime gun bans for nonviolent felons. History suggests only violent offenders were disarmed. A ruling could restore rights to millions with nonviolent records. The biggest question: can states ban popular semi-automatic rifles like the AR-15? The court's choices on which cases to hear will signal how far it's willing to go in reshaping gun laws. Each case could spark another landmark decision. Let's clear up the rumors. There's been no shocking 9-0 Supreme Court ruling on gun confiscation, no new law, no unanimous decision, and no order to seize firearms from law-abiding citizens. The big cases are still pending, and the court remains deeply divided on gun rights. Past decisions have been narrow splits, not sweeping consensus. Misinformation only fuels fear and confusion. The court is moving deliberately, case by case, not issuing surprise decrees. Always check credible sources for updates. The real changes will come slowly, through written opinions over months and years. The future of the Second Amendment hinges on how the court applies the history and tradition test in upcoming cases. Watch for how literally the justices demand historical analogs and which era's laws they prioritize. The court's orders in the coming weeks will reveal which new cases it's willing to tackle. The reasoning in concurring and dissenting opinions will show how united or divided the justices really are. Moderate justices like Roberts and Kavanaugh could shape the scope of new rulings. Whatever the court decides, state legislatures and Congress will respond, shaping the real-world impact. Expanding gun rights could trigger deregulation in some states and new restrictions in others. The debate over guns isn't ending, it's evolving. The Supreme Court is just drawing the next lines in a centuries-old battle.